All rise.
Yes.
Department 16 is now in session. Honorable Timothy Lynch presiding. Please be seated.
Thank you, ma'am. And let's go ahead and set forth our appearances for the record. We'll start first with the plaintiff, then we'll move to the defense.
Kemp, Pepperman, Theodore.
Good afternoon, Your Honor. Joel Odou, Facility Lifestyles.com, Inc., Real Water, Inc., and Real Water Real Estate.
Morning, good afternoon, Your Honor. Scott Rasmussen on behalf of Hanna Instruments, Inc.
Afternoon, Your Honor. Jim Neale and David Spurlock on behalf of the UNFI.
Morning, Your Honor. Cavanaugh, Real Water, Tennessee, LLC.
Good afternoon, Your Honor. Rob Robbins, Milwaukee.
And I think that covers all appearances. Is that correct?
Yes, Your Honor.
All right. So, I have my list, and I've been kind of anticipating where we go. Where are we going from here?
Your Honor, there's been one correction. Mr. Robbins requested that we move 18 till first up tomorrow.
That's fine.
So that was Plaintiff's motion number 18 on Dr. Kinder. So I think that takes us to the two, you and I have motion for summary judgment.
All right, and which one are we looking right here?
Those are on the individual claims, Your Honor. We've already done the punitives. This would be on Mr. Haley and Mr. Belsky, or I think it's in the opposite order, Belsky and then Haley.
All right.
Here, these are the same spreadsheets and the affidavits for the intended problem.
Should you do something?
I need this.
Of course.
Your Honor, Jim Neale on behalf of UNFW.
Yes, sir.
Your Honor, these are two separate motions for summary judgment, but and while the underlying facts differ, the basic argument is the same. So with the court's permission, I'll address Mr. Belsky's and then Mr. Haley's, and then the facts comment both, if that makes sense.
It makes sense.
Your Honor, as you know, Mr. Haley and Mr. Belsky are the two plaintiffs in the Gallagher case who allege injury as a result of drinking retail real water. And each is pressing a claim against United Natural Foods West. Each alleges purchases at Whole Foods. Each alleges that UNFI distributed, and the court has already granted summary judgment over UNFW's objection on the fact that UNFW distributed that water. Mr. Belsky also alleges consumption of 5-gallon home delivery water. And Mr. Haley does not. He is exclusively a retail bottled water drinker. And Mr. Haley, I don't think I'm out of turn saying this, has accepted an offer of judgment from Real Water. So his only claims remaining are against UNFW and the metering defendants. So UNFW now moves, Your Honor, for summary judgment on both of those individual claims. The obvious effect of that would not be to kick the plaintiffs out, but to kick UNFW out so that Mr. Haley would still have a claim against the metering defendants, and Mr. Belsky would still have his claims against both Real Water and the metering defendants. The basic premise of both summary judgment motions, Your Honor, is the same. That is this: neither of these gentlemen, according to their own testimony, drank enough of the water close enough in time to their hospitalizations to have been the plausible cause of their liver injuries, according to their own experts. Let me start with Mr. Belsky, Your Honor. Understandably, his injuries were May of 2018. And I'll start with this. Both of these gentlemen differ from the public health authority's case definition in several important regards. Number one, they're years prior to the outbreak. Mr. Belsky is May of 2018. Mr. Haley is August of 2019. As the court's aware, the public health authorities defined the case beginning August 1st, 2020. The public health authorities found that every probable case was a 5-gallon consumer. None were exclusively retail consumers. And the public health authorities, Your Honor, found that the vast majority of cases, I believe 20 out of the 21 probable cases, were daily consumers of real water, which is not true for either Mr. Haley or Mr. Belsky as to the retail water. So they're outliers in all those important regards. Mr. Haley is also a further outlier geographically. He is the only plaintiff in this or any other case that alleges liver injuries as a result of consuming real water, but is outside the home delivery area. He resides in Reno, Nevada. All right, so with that general introduction, Your Honor, I'm going to start where the Wilson versus Circus Court instructed us to start in a foodborne in this case, which is to say that circumstantial evidence can suffice, but there's a higher degree required when there's no obvious problem with the water, with the food. And that's certainly the case for Mr. Belsky. John, could you play the clip for no problems drinking, please? This is Mr. Belsky's deposition, Your Honor, asked about what he noticed amiss, if anything, about the retail real water. The real water that you purchased at Whole Foods, Mr. Belsky, did you ever notice any problems with the bottle cap or seal on those?
Not that I can recall.
Did it look normal to you?
Yes.
No foreign objects?
No.
No, what's the right word, turbidity, cloudiness?
Not to my recollection, no.
Did it smell normal, as far as you recall?
As far as I recall, yes.
And did it taste normal?
Yes.
In fact, you liked all of those things enough to pursue the home delivery after drinking it?
Correct.
No chemical smell or taste,
Not to my recollection,
and certainly no unpleasant physical sensations when drinking it?
no.
No burning or itching or?
No.
So in that regard, Your Honor, Mr. Belsky's experience with the retail real water differs from every single complaint that the court is allowing into evidence, whether that be a foreign object, a visual problem with the water, an off taste, off smell, or any physical problems after drinking it. The bigger issue in Mr. Belsky's case, Judge, is that he stopped buying retail real water. He bought the last bottle of it many, many months before he was hospitalized. John, could you please play the clip at Stop Buying Retail? This is page 94, line 10, Mr. Belsky's deposition. And then you provided us and then when you got the home delivery, you stopped drinking, you stopped buying the retail product.
Correct.
Did you ever, you must have occasionally bought bottled water after that.
Well, as I mentioned earlier, I occasionally bought distilled water for use in small home appliances, like a tea kettle, that type of thing. Sure, there would be times if I went to a gas station and I was thirsty, I might buy a Dasani or something like that, but
No retail real water purchases after that.
not that I can recall.
Do you recall the last time you consumed retail real water?
I couldn't tell you an exact time. It would be in that time frame of some trip to Whole Foods just prior to the first delivery of the 5-gallon jug. And into that post-delivery period where there might have been some bottles still in the house.
So Mr. Belsky is understandably uncertain about any specific date that he bought or consumed the product, Your Honor, but he can anchor it with certainty by the home delivery records. When he stopped buying real water and then would have, in his own words, occasionally could very occasionally, I think, consumed one of the stray bottles left in the house thereafter. Your Honor, I want to go through then the timeline of his home delivery, because I think that's what distances his purchase and consumption of retail water from his May 24th, 2000 injuries. John, if you could just pull up the medical record first, please, at Belsky R0200. Mr. Belsky first went to the emergency room, Your Honor, I think in the upper right-hand corner there, John, on May 24th, 2018. And that was his first, there's no allegation of a liver injury prior to that date. So if we work backwards from there, Judge, we can construct a timeline that enables us to identify the last date on which he would have purchased and shortly thereafter consumed retail real water. And the reason that's important, obviously, is because of his expert's testimony about latency periods and quantities necessary to cause toxic injuries. So going back in time, Your Honor, at his deposition, we were aware of an April 11th, 2018 check. John, if you could pull that up, please, it's Belsky 0267. And at the time, Mr. Belsky testified that this was a check for his first delivery of 5-gallon water, and this would have been about 6 weeks prior to his hospitalization. But what we found, Your Honor, is that documents produced by both Real Water and Mr. Belsky subsequent to this showed that he'd been receiving Real Water for many months prior. John, let's go to Real Water 220648, please, the delivery route sheet. In the upper left-hand corner, Your Honor, this shows, and it's obscured by the stamp there, but when Mr. Stevens pulls it up, you can see that it's the delivery route sheet from March 7th, 2018. And that has Mr. Belsky's address of 554 Cracken Drive on it. I may have that name wrong, John. Pull out of that if you would, please. His name is the first on that bottom group, John. 554 Bracken Avenue, excuse me. But that's not the first delivery either, Your Honor, because Mr. Belsky subsequently produced additional documents showing, this is the February 12th check, John, 00341, showing that he was purchasing retail Real Water from Real Water Las Vegas directly on February 12th. And you may recall, Your Honor, he testified that he paid $9 a jug. So this would represent a delivery of 4 jugs sometime shortly before February 12th, 2018. That's consistent with billing statements he produced. Belsky 340, please, John. This statement from Real Water, Your Honor, shows that Mr. Belsky, first of all, in the upper right, John, it's dated January 31st, 2018. Thank you. And it talks about delivery of water. John, if you can go down to the bottom, please. Well, let's go to the columns there in the middle of the page. It talks about deliveries that were made on January 2nd, 2018, and January 30th, 2018. So, Your Honor, we're now 5, almost 6 full months, according to that earlier date, prior to his hospital visit. And you'll recall his testimony that he stopped buying and drinking retail Real Water prior to this date. Finally, Your Honor, would you go to the bottom of that, please, John, if you would, and show the court the different delivery dates. We know that he's regularly taking water in his home, Your Honor, from these scheduled deliveries on 2/13, 2/27, 3/13, and 3/27, every 2 weeks. Finally, John, if you would, Real Water 03543, we have a service agreement, Your Honor, dated November 13th, 2017, for Mr. Belsky at 554 Bracken Avenue, which appears to have initiated the home deliveries. Your Honor, at that point, Mr. Belsky's drinking the same thing that all 5 children airlifted to Utah were drinking, all 21 of the identified probable cases were drinking. That's the 5-gallon Real Water product. And at that point, he had stopped drinking the retail product. Less there be any doubt, John, if you could play the 100% clip, please, for Mr. Belsky's deposition. He testifies that at this point, his retail bottled water consumption tails off entirely and is replaced, I think his exact words are, virtually 100% or nearly 100% by 5-gallon water.
Towards the end of that, of course, with the 5-gallon jugs, and when the retail bottle purchases stop, the ratio goes pretty much 100% to the 5-gallon jugs. But that's just before I got sick, so I can't say.
Pretty much 100% 5-gallon jugs after the delivery of those jugs.
Yes.
In fact, Your Honor, you'll recall Mr. Belsky perhaps testifying that even the retail bottles that he would have had from prior purchases, he thereafter filled up from the 5-gallon jug container in his home. Now, his mother did testify that she found sealed retail bottles in the refrigerator. That obviously contradicts Mr. Belsky's testimony, but setting that aside, which I think the court has to, because Mr. Belsky didn't drink that water and Mr. Belsky didn't buy
Why
them.
do I have to do that?
Because he says, I stopped.
Wait, no, I didn't interpret it that way. And you're saying, look, Judge, you have to set that aside. I don't make any factual determinations unless it's an uncontroverted fact.
The uncontroverted fact is this, Your Honor. Mr. Belsky says, I stopped drinking retail real water, and I went 100% to the 5-gallon water when I started the home delivery. That's an uncontroverted fact on Mr. Belsky's
Does he
part.
say it exactly like that? Go back to that and show that again.
Yes, sir.
Towards the end of that.
I want the question. I want the
5-gallon
question.
jugs
Okay,
and-
Your Honor.
I want the question.
I understand, Your Honor. Let me pull it up for you. John, could you please pull up the transcript at page 119? It'll be just before line 16. Let's start at line 7 for the court, please, John. Your Honor, you'll keep in mind, this is when Mr. Belsky thought that that April check was the first home delivery. And the documents he produced thereafter proved that it wasn't. So that's why the question reads January to April of 2018. But his answer, I think, is very clear. His answer is, I was drinking both. Toward the end of that, with the 5-gallon jugs, and the retail bottle purchases stopped, the ratio goes pretty much to 100%. That's just before I got sick. And again, at page 94,
Wait, go back to that again. Scroll down. I want the. Okay, he says, I can't know that. I was drinking both during a time period between January and the delivery of water in April. I was drinking both. I can't recall the exact quantities or ratios of which. Towards the end of that, with the 5-gallon jugs, when the retail bottle purchases stopped, the ratio goes pretty much 100% to 5-gallon. But that's just before I got sick, so I can't say.
yes, sir.
So what does that mean? So you're saying that stands for the proposition that there's no issues of fact that by the time he hit the latency period, that there's no evidence to support the position that he was still drinking retail bottles? Is that what you're saying?
Yes, sir.
Okay. All right, I got it.
And he not only says that, but at page 41, line 22, he says, after I got the 5-gallon delivery at home,
Wait, pull that up.
I started taking the retail jugs that were empty and filling those with the 5-gallon water. That's his testimony, Your Honor. He said, I don't know when that happened, but it happened whenever I started buying the 5-gallon delivery. And he says, at page 85, please, John, lines 13 to 18, he says, I don't know exactly what that date is, but the real water records will give it to us.
All right.
right? So that's why we go to the real water records that Mr. Belsky had in his possession, but had not produced at the time of his deposition. And those later produced records, Your Honor, clearly show that this date was many months before he first thought it was, that it was November of 2017 when he started getting home delivery, that he got very regular home delivery thereafter, that he stopped buying retail, that whatever retail was still in his house, he filled up from the 5-gallon jug, and that he was 100% consuming 5-gallon water. The earliest documentary proof we have of that is November 13, 2017. Those are uncontroverted facts from Mr. Belsky's own testimony.
And you say the uncontroverted fact is the fact that the latest time he was drinking retail real water would have been November 17th of 2017?
Yes, sir, and I think we have to, in fairness, give him, he was very clear that that was his latest purchase, and that he may have consumed a bottle or two that he had purchased before, shortly thereafter. So I don't, it doesn't matter what the court wants to give him there, you can give him a month or two. But it still
But I
puts,
can't give him a month or two or anything. I mean, that's kind of my point. I mean,
well, you can, Your Honor, because he's still outside the latency period, and according to his own experts. And he's,
but my point is, I'm not giving him any benefit of the doubt or any detriment.
well then,
It's just whatever the facts.
those are the facts, Your Honor. Those are uncontroverted facts from Mr. Belsky's sworn testimony. All right, I'm gonna shift, if I can, to Mr. Haley's fact. Well, let me do this first. Your Honor,
No, we can shift. I'm following.
Well, I'd like to do one thing, if I may. I know the court has ruled from the bench on the purchase date. I feel like I need to proffer that in support of this motion, Your Honor, not expecting the court to reverse itself, but to put it into the record for preservation
Oh, of
purposes.
course, you have a right to do that.
Thank you, Your Honor. So this is in the motion, and I think we're okay here, but I want to go through the purchase data and show how that's perfectly consistent with his sworn testimony. One corroborates the other. John, if you could please pull up Belsky 271. Mr. Belsky produced in the course of this litigation credit card data.
And so we're still on Belsky.
We're still on Belsky, and I jumped prematurely, Your Honor. Still on Belsky. Mr. Belsky produced that credit card data, Your Honor, to show all of his purchases that he could document at Whole Foods. This is an example. So we have a date and a store and an amount. With me so far, Judge?
I'm with you. You're 115.18.
Yes, sir. And that would be, as the court may recall from the earlier timeline, just after the home delivery. So if Mr. Belsky's recollection is correct, that he stopped buying retail water when he got the home delivery, we wouldn't expect to see any retail real water purchases among these items. Exhibit K to this motion, please, John. We then received a discovery request from the plaintiffs. Again, I don't mean to re-argue against the court's ruling yesterday, but the plaintiffs asked us, and this is our response. John, if you could just go to the first of the questions, please. Interrogatory number 12 is an example, Your Honor, and that refers to the same credit card entry you just saw. John, thank you. Perfect. Please state in detail the contents and the items purchased within the Whole Foods transaction on or about January 15th, 2018 for $255.25, referring back to Belsky 0271. All right, the plaintiff is identifying the credit card transactions. The plaintiff is serving discovery requests, asking us to match those transactions to individual purchase data. Can we scroll down to the next page, John? We do that. And we identify all the items that were part of that transaction from Mr. Shank's SQL query of the purchase data from the point of sale. And there's no real water, which again is consistent with his testimony that he would have stopped purchasing retail real water at that point. John, can we go to the next page? There is a corresponding question, Your Honor, for each of 1, 2, 3, 4, 5 different shopping trips to Whole Foods that Mr. Belsky made. There is no real water in any of them. Each of those transactions matches to the penny with his credit card data. 5 dates, 5 specific amounts, 5 separate transactions. All right, then we produced, Your Honor, and I'm going to proffer to the court if I can, Eric.
Yes.
May I approach, Your Honor?
Oh, yeah.
This again, Your Honor, and I'd ask that it be made part of the record on this motion, is the purchase data. Tab 2 is, well, included in there, Your Honor, are all of the Haley spreadsheets, all of the Belsky spreadsheets, and the 3 affidavits, one from the custodian of records, Mr. Schenk, one from Mr. Henfling, one from Ms. Anderson, attesting to their authenticity.
Your Honor, on behalf of the plaintiffs, we want to present an objection to that. None of those documents were actually identified in the motion or the reply brief. I think this is a kind of last-ditch effort to re-argue what's already been argued more than once, Your Honor. So, I thought when he said proper, I thought he was talking about proper in an argument, not actually adding exhibits not previously mentioned in the motion or the reply. So I just want to make sure the court is clear and the record's clear. These documents were not attached to either the motion or reply submitted by UNFI.
Your Honor, they are, the discovery responses that we just went over are, the discovery responses incorporates Whole Foods 000637, which is the spreadsheet at issue here. All of the discovery responses that are attached as exhibits to the motion do the same thing for Mr. Haley as well. In fact, I think that the purchase data itself is referenced there, but if not, the discovery responses, which incorporate the purchase data, certainly are. There's an entire section of the motion for summary judgment about the purchase data and an entire section in the response about the plaintiff's exceptions to that purchase data.
Again, Your Honor, I'm not trying to suggest that Mr. Neale's motion and reply may not reference discovery. It doesn't attach or reference, I should say reference, it doesn't attach these documents. These documents are simply not a part of the motion or reply. And I think you concede that point. Maybe they reference them, but they're not attached to these documents.
That's right, Your Honor, and the court will recall that we didn't attach them to any motions because they have, among other things, personal identifying information in them, including some credit card information. So that's why we didn't do it. We made that point in the motions concerning these documents. That very spreadsheet is incorporated into the discovery response, which is referenced, attached as an exhibit, and referenced repeatedly in the motion.
Your Honor, that's another reason why the court can't take them. Our rule in this jurisdiction is that it has personal identification information, they're supposed to be redacted. We have a 16.1 certification that you don't provide personal identification information in documents, so they shouldn't be a court document now as well.
I was getting ready to say, if there was an issue regarding a credit card number and personal identifiers, that could always have been redacted and attached as a copy to the motion. That doesn't prohibit it.
That's true. So that, for that reason alone, Your Honor, if there is personal identification or identifiers in those documents, they shouldn't be provided to the court, and they certainly shouldn't become a court's exhibit at this point.
Your Honor, you'll recall that there is an encrypted token there. There is Mr. Haley and Mr. Belsky's shopping habits. Forgive me for trying to protect their privacy. I don't think there's anything that prohibits the court from accepting that as a court's exhibit. The documents are referenced in the motion, and in fact, they form a court.
But see, this is the problem. And what I mean by that is, for example, before the deposition that was taken in this case, documents should be produced in a certain way. And I'm looking at it, I understand these documents were produced. They're subject to some, I guess, the motion practice, we can say that. And just as important too, if we're going to argue over specific entries that are contained in this spreadsheet, from a fundamental fairness perspective, don't you think the adverse side should know about it and at least have an opportunity to comment in their opposition?
Your Honor, they do, they have, the opposition is full.
But I mean, let's keep it straightforward. For example, if you're gonna rely upon certain documents as a basis of your motion for summary judgment, those documents should be included with the motion, right? And we have a great quote, and I can't remember where it comes from. It's just like with trial judges, we shouldn't have to paw through and determine what a party's relying on in order to seek whatever relief they're going to try to obtain from the trial court. I mean, and I'll say this is actually two levels. First of all, from my perspective, I should have the documents to look at pre-hearing, number one. I think everyone should agree. And just as important when it comes to the adverse party, they should have the documents too. And know that, you know what, this is what we're gonna rely upon, judge in detail, and it should be attached. And if it's not attached, I don't see how anyone would know to go look at those documents and check them. I mean, really and truly, we've all been practicing in this jurisdiction for a long time, and that's just how things are done, right? If you're gonna rely upon a document, you attach it. So it impacts my ability, and this is important too, it impacts adverse counsel. I don't think that can be overlooked, but go ahead, sir. I understand you're making a record, I do. I get it. This is, you know what, I'm gonna say this. These documents should have been, if you're gonna, specific entries you wanted me to look at, it should have been, because I'm looking here, and I don't know how many entries are there.
There are 1,000, Your Honor. The point is this, if I may, there are none for retail real water. That's the point that's made in the brief. That's why the plaintiffs have moved to exclude that evidence. It kills their case.
Well, I mean, but here's the point. There has to be, it's kind of like, this is how I see it. You don't get to make your own evidence, right? You don't. And that's part of it. That's kind of what happened here. And I know you pulled your glasses off, but here in Nevada, we kind of do things a certain way, right? You produce, because I don't mind saying this, I don't think I've ever seen a spreadsheet that's been authored by a lawyer.
Your Honor, I don't know what I can possibly do to disabuse the court of the notion that this was authored by a lawyer, but it wasn't.
Yeah, well, I mean, I remember looking at the spreadsheet, or what, the Excel spreadsheet.
Yes, sir.
And those types of things. And you're saying, look, Judge, I mean, for example, what was the term of art utilized as far as the search term, SQL? Was that-
SQL query, Your Honor.
Yeah, SQL query. I mean,
It's, Your Honor,
because one of the fundamentals of civil litigation is each side has a right to test the veracity of evidence. They have a right to test the foundation for evidence, right? And so what has happened here is, and this is kind of how I view it, at least from the bench, is, okay, here it is, trust us, but you don't have to verify.
absolutely not. Your Honor.
And isn't that kind of what Ronald Reagan said?
He says, trust but verify.
Right.
Your Honor, and let me,
I mean, that's how I'm looking at it.
the Gipper was right. That's why all of these documents were listed on our 16 warrants. That's why the witnesses,
But all these documents, if it's my recollection, is 16.1 production specifically dealt with gross sales per
no, sir.
store.
That's
That's what was given to me, gross
Judge
sales
Lee.
per store, that's what my recollection was.
Your Honor, the plaintiffs asked for sales information. That was Whole Foods 180. That was certainly listed on the 16.1. That has nothing to do with this.
But that's my point.
Your Honor, if I may, each and every one of these documents was a response to the plaintiff's specific discovery request.
So we'll be
And-
clear,
And
the 16.1 productions were not these documents.
no, Your Honor, exactly the opposite.
Well, no, what do you mean? Either they were or they weren't.
They were. Every single document in front of the court was listed on the 16.1, repeatedly. Every single one.
So are you saying that these documents were produced at the time of the 16.1 early case documents?
Not the initial one, Your Honor, but some.
Oh, okay, that's kind of my, okay.
Well, Your Honor, the initial ones,
So you're saying these were produced as a result of a request for production of documents?
yes, sir.
See, there's a difference. There's a difference. There is a difference.
All right, Your Honor,
So what we're doing is we're kind of talking by each other. So these were produced as a result of a 16, or a Rule 34 production of documents.
or an informal letter, but in any event, every single one of them made its way onto the 16.1, as did the identity of the witness who's attesting to their authenticity.
And when were these, when did this become part of the Rule 34 or 16.1 production? A date?
Well, I can give you a date for each one if you'd like, Your Honor. But it was staggered, it was seriatim as we got subsequent requests from the plaintiffs. The plaintiffs drove this train from the very beginning. They said, show us your purchase data, Whole Foods. And so we responded to each of their requests. As the first one proved to be a dry hole, we got a second one for a more expansive date range. We produced that. We listed it on 16.1.
And does this have cash?
Yes, Your Honor.
And
So
how
Haley's,
do you identify cash?
well, we've been over this, Your Honor, but if you'll recall, on Mr. Haley's, there
We're
is,
talking about Belsky right now.
we're talking about Belsky. Belskys do not have cash. There's no way to link a cash purchase to Mr. Belsky. There's no way at all. So, and that's not what was requested by the plaintiffs. It's impossible. When someone comes into Whole Foods and pays cash, we don't demand an ID, and we don't make the purchases to an ID. All we can do for Mr. Belsky, and he's free to come into court and say, I paid cash for something, but he didn't. His testimony was the opposite. His testimony was, I stopped buying real water altogether once the home delivery began. All right. So setting aside, I don't mean to get hung up on the purchase date, Your Honor. I want to proffer that and make it part of the record. It's referenced in the motion. It corroborates Mr. Belsky's testimony. He says, I stopped buying real water at the end of 2017 when the home delivery came. That's exactly what the purchase data shows. No purchases of real water thereafter. All right. He then, Your Honor, found more credit cards for us. Again, John, if you could play the clip at page 110 of his deposition beginning at line 2. He was deposed, he gave us his, what he called his daily driver credit card. That proved to have no real water purchases attached to it. Then he came up with other credit cards he wanted us to chase down.
And you only asked for the chase information after you learned that the data you had previously provided showed no real water purchases.
Or privation.
Can I say that for a second?
Yes, that's correct.
And you only requested the closed Amex account information after you learned.
No, that's not true. I tried, sorry,
When did you request the Discover card information?
yesterday.
And that was after you learned that the data you had discovered so far showed no retail or real water purchases at all.
Yes.
Or privation.
And so, confronted by the fact that there was no retail real water purchase information reflected in your credit card statements produced today, yesterday, you began a quest for more data.
Or privation.
Yes.
So, Your Honor, we're playing whack-a-mole here. We've been given some credit card information. We've been asked to produce the purchase date that correlates with that. We do that. We come in and depose Mr. Belsky, and for the first time, he says, well, I've got more credit cards coming. Then we get those, and we produce subsequent data at the plaintiff's request responsive to those transactions. That's tab 4 of your binder, Whole Foods 00638. Then, Your Honor, there are still more. Exhibit L to the motion, please, John. We get more credit cards that Mr. Belsky had because nothing to date has shown any real water purchases. And we again produce documents responsive to that. John, if you could go to page 6, please. There are a number of requests, again, for specific transactions. and we produce more itemized purchase data in response to that. This is long after his deposition. And this is why there are several subsequent productions over time, and why we can't do anything before getting these requests, because we don't know what the credit card data would be. We don't know the dates of the transactions, the amounts of the credit card used. The plaintiff, again, is driving this train entirely. All right, all of this is to say, Your Honor, that despite 3 separate requests and 3 separate spreadsheets identifying multiple transactions in each, there is no 2018 or later purchase of real water for Mr. Belsky. There's no documented purchase at all. And his testimony, again, is consistent with that. So let me, unless the court has questions about Mr. Belsky, move on to Mr. Hale.
I'm just looking at the spreadsheet, I just want to make sure I'm clear. I'm looking here. And store number, date identifier, transaction time, terminal number. Does it have employee numbers?
It does for Mr. Haley, Your Honor. He's the employee.
Okay, but Mr. Belsky?
Mr. Belsky's a customer off the street.
All right,
There's no employee number.
I understand.
So in Mr. Belsky's case, these transactions are tied to him with his credit card. In Mr. Haley's case, the transactions are tied to him with his employee discount card and include cash, credit card, and everything else. Now, finally, Your Honor, I'll just say that, again, Mr. Belsky, by his own admission, was purchasing 1 to 2 small bottles of real water at retail a week. 1 to 2 a week. He did that through November of 2017. He started getting home delivery. He stopped buying retail real water. And he was hospitalized for the first, he went to the emergency room for the first time on May 24th, 2018. 6 months after his last purchase, according to his testimony or the purchase data. At least 6 months. Are we good on Mr. Belsky, sir?
Oh, yeah, I'm done.
All right. Now, if we move on to Mr. Haley, Mr. Haley is the employee in Reno. Mr. Haley testifies, Your Honor, that he never had home delivery. It's outside the home delivery area. He is the one and only plaintiff in this case who did not take home delivery. He's unlike the other 6 plaintiffs here. He's unlike the other 5 children in Utah. He's unlike the other 21 probable cases that the public health authorities have identified. So, John, let's just, to emphasize that point, if we, let's just go to Exhibit I, if we could, please, to the motion. This is a CDC presentation, Your Honor, done by the head EIS officer. She's the CDC epidemiological intelligence officer. She's the one looking for cases after the outbreak. She's what's the right word? Seconded to the Southern Nevada Health District. John, can we go to page 15, please? All right, so at the end of their case finding efforts, they've got 21 probable cases and they've got 4 suspect cases. And all but one of these people drank real water every single day.
Thank you.
Page 16, please, John. All 21 of the probable cases, Your Honor, drank the 5-gallon product. All right, Mr. Haley is very different in both regards. Mr. Haley's sworn testimony is this. Well, John, let's go to the video clip, please, on the sporadic consumption. Page 81, line 16. It's a new product, it's on sale. If I heard you correctly, you buy it 3 or 4 times that first week you see it.
Yeah, the first time I saw it, I bought it more than once, and I drank it more than a few times. And then after that, I drank it maybe a handful of times after the first time, trying it, or after that first week.
And help me understand, how many times is a handful?
Handful, maybe 5 or 6.
All right, so when it shows up for the first week, you drink it 4 times.
Yeah, more often, and then after that, it was more sporadic.
More,
It was less.
more sporadic, maybe 5 times total.
Correct.
All right, Judge, Mr. Haley testifies that he buys a grand total of about 4 bottles the first week it shows up in his store. You know from looking at the sales data, that was sometime in 2017, 2 years before his injury. Then, after that, he buys it a handful of times, maybe 5 or 6 total. That's it. Nothing more than that. And unlike Mr. Belsky, he doesn't have a 5-gallon jug at home. All right, he's drinking, John, can you pull up the map slide? Your Honor, he's drinking the retail bottled water only. And these maps are from the same CDC Southern Nevada Health presentation you just looked at. On the right, it shows where UNFW and Kihei and others were distributing the retail bottles nationwide. On the left, it shows the home delivery area.
I'm sorry, Mr. Neale, what exhibit are you referring to in your motion or reply?
I'm referring to Exhibit I,
In your reply, or you?
motion. The same CDC code, the base numbers are there. Right, Your Honor, Mr. Blaine Jones, who gave the 30B6 for real water, explained that home delivery accounted for no more than 10% of the company's business. That's the area on the left. 90% of the business was this retail bottle distributed to the Reno Whole Foods and every other store, many other stores in America. To reiterate the CDC and Southern Nevada Health's findings, every single one of the probable cases was a daily drinker of real water who had a 5-gallon jug at home and who drank it within 30 days of their illness. CDC and Southern Nevada found 0 cases associated with the exclusive consumption of retail water. 0 cases who weren't daily drinkers. And 0 cases outside the home delivery area. All right, that's how far of an outlier, and 0 cases before August 1, 2020. All right. Like Mr. Belsky, Mr. Haley had no complaints at all about the water he drank. John, can you play that clip, please, at page 150? No issue with the water he drank. Line 16. Were the bottles you drank from all sealed, as best you could tell?
Yes.
Did they look, smell, and taste normal to you?
Yes.
No chemical smell, no off color?
Not that I know of or can remember.
If that had happened, you're not the kind of guy who, you would raise that issue to someone and make sure other people knew about it.
If something was off, I would probably raise that issue.
No chemical taste that you recall,
I can't recall.
and no immediate symptoms or burning sensation.
Not that I can,
No foreign objects of any sort in the water that you saw.
no.
Certainly no mold or fungus or insects or cardboard or.
No.
And we agree that if you had seen anything like that, you would have brought it to the attention of somebody at Whole Foods
Yes.
or Real Water.
Yes.
And you never did either of those 2 things.
No.
Right. So again, by his own testimony, he buys 4 bottles the first week the product shows up in the store, which we know is no later than 2017. Then thereafter, he sporadically buys an occasional bottle. And that's what he testified to, and that's what his coworkers testified to. Mr. Haley doesn't go to the hospital, Your Honor, until August 13th, 2019. There are at least 1 year and 8 months between the first week when he purchased 4 bottles and his hospitalization, during which he says by his own testimony, he purchased and consumed no more than, I think his testimony was 4 or 5 or 5 or 6 bottles of real water, all without incident. No symptoms, no complaints, no problems, nothing. Again, that is perfectly consistent with the purchase data that we produce, which I'll proffer in Mr. Haley's case. It's Whole Foods 0181, Whole Foods 0636, Whole Foods 0641. Those, Your Honor, show one purchase of retail real water. And the broadest request we got from the plaintiff was beginning January 1, 2018. Those show one purchase of retail real water on March 5th, 2018, 1/2 liter bottle. Again, that conforms to his testimony about sporadic purchases. That confirms to his coworker's testimony. He said, yeah, we sold him real water. I remember seeing him with real water. I remember him joking about real water. I think it was 2019, but both of them said it could have been 2018. Even if it were 2019, Your Honor, none could put it proximate to the August 13, 2019 hospitalization. All right, so those are the facts regarding Mr. Haley. I'll move now to their expert opinions and why those facts entitle UNFW to summary judgment if the court doesn't have questions.
No, let's go ahead, because I was waiting for you to go into the expert areas.
Okay. Can we show the Freeman latency slide, please? Your Honor, you'll recall.
What is Dr. Hudson plan is?
Well, I was going to do him next. I can skip him first if you'd like.
Because this is my understanding, didn't he opine causation opinions as to all 7 plaintiffs in this case?
Well, he did, Your Honor. You'll recall that in Mr. Haley's case, his specific opinion was, in Mr. Belsky's case, it was impossible to sort out the retail real water from the 5 gallon. But what he said, he did, Your Honor. He said real water, period. He didn't specify retail or 5 gallon in his report caused these injuries. And then when he talked about his latency period, John, if you could go, let's come back to this. The judge wants to look at Hudson first. Let's go to page 120, line 15. Dr. Hudson said, talking about the latency period, which is one of the circumstantial tools that Wilson versus Circus says we should use. He says, the question is, what's the latency period for ingesting hydrazine is what we're talking about. Nobody knows exactly what it is. It's all been hypothesized. Looking at drug-induced liver injuries in general, latency period lies between 2 and 20 weeks. So again, if we use the longest of those periods, something can cause a liver injury 20 weeks after it's ingested. That's Dr. Hudson. Dr. Freeman, and you recall he's our med.dr doctor.
Now here's the thing. He was talking about drug-induced latency periods. I mean, I get that, I understand that. And, but he says it's all been hypothesized, right? And he says nobody knows exactly what the latency period is, and maybe because there's no studies as it pertains to the exposure to hydrazine. And so here he's talking about, now when you look at drug-induced liver injuries in general, the latency period lies between 2 and 20 weeks. Now here's my question when it comes to latency periods for hydrazine exposure.
Well, I think, Your Honor, this is a drug-induced liver injury. And so this is the larger category of injuries, whether it's caused by hydrazine or acetaminophen or augmentin or...
But I mean, that's a tell me, I mean, is hydrazine a drug that's used? Or is it a chemical compound of some sort, you know? And here's my point, there's a distinction, because, for example, I would anticipate when studies are conducted by all the different research universities and the like as it pertains to drugs, they run studies, they run blind studies, and they look at new drugs that come on the market. Those are studied in a significant way. I mean, the best example would be all the COVID vaccines. But my point is this, when it comes to hydrazine and its impact on the human body and what the side effects are and those types of things, have we had the same types of studies?
Well, Your Honor, there are myriad studies involving hydrazine. It is a drug. It is prescribed. It is absolutely something that causes drug-induced liver injury, according to Dr. Hudson.
But my point is this, he says nobody knows exactly what the latency period is.
Yes, sir. So, but he's putting it in this larger category, the longest extent of which is 20 weeks. That's what Dr. Hudson's testimony is showing. He's not going to come into this court and say that hydrazine has a latency period of more than 20 weeks.
But I mean, does he say that in the deposition testimony?
Your Honor, I think this is as much as he says about it. He is saying that there is no known drug-induced liver injury that can occur more than 20 weeks after the ingestion of a substance, any substance. That's his testimony.
Well, I read it slightly different.
All right.
I see, no, in this quoted now, when looking at drug-induced liver injuries in general, the latency period lies between 2 and 20 weeks.
Yes, sir.
That's what he said.
That's what he says.
And then you look here and you go to his opinions, he opines, like for Mr. Belsky's, the ultimate diagnosis, or his opinion, I should say. Richard Belsky developed acute liver failure in May of 2018, secondary to consumption of water.
And it was impossible, he continued, to separate out the retail bottles.
Okay, but I mean, but my point is this, he does give that opinion, right? He does. And he does the same thing regarding Mr. Haley.
He does. You understand that that opinion doesn't have anything to do with UNFW, as to Mr. Belsky.
Well, I mean, we'll talk about that a little later, but I understand the distinction, but what is, but he gives an opinion. I guess we can start from this first point. He gives an opinion that both Belsky and Haley developed acute liver injury, and he gives dates secondary to the consumption of real water.
He does, that's right. And then he gives a latency period. And the consumption, both of their consumptions, although he was unaware of this fact, both of their consumptions lie well outside that latency period. Now that's strike one. I'll move on unless the court wants to talk more about Dr. Hudson, but we agree on those basic facts.
Okay.
All right, Dr. Freeman, the med.dr doctor. John, can you let's go to his deposition. Well, let's go to the slide, please, that has the deposition quote on it. All right. Dr. Freeman says the latency period is days to weeks, Your Honor. This is page 38, line 17 to page 39, line 15. If it would be longer than that, as long as it wasn't more than weeks prior, there's no problem with the latency period. He clarifies, if someone says, I drank real water last year, and this year I have symptoms and started throwing up, it would be temporally implausible that the two things would be associated, as an example. He says he's typically seen it as several days to maybe a week or more. Nowhere near the time periods we're talking about. Nowhere near. This again is the plaintiff's own causation expert, to the extent that the court allows the opinion at all. All right, so both Dr. Hudson and Dr. Freeman place both Haley and Belsky well outside the latency period according to their own testimony, the purchase data, and everything else that might document the purchase and consumption of water. I would say that's strike two on both of the plaintiffs. Any questions about Freeman's latency period?
And bring that back up again on his latency period.
It's right there, sir. This is an excerpt from page 38. We can pull the deposition if you
No,
want.
no, no, I don't need to. And you're talking about line 17, is that?
38, line 17, yes, sir. And then the conversation continues on page 39, line 15, through line 15. I would not say multiple weeks. He has it at less than 2 weeks. Mr. Haley testified that he didn't drink any retail real water the month of his hospitalization.
Right. Yeah, go ahead, sir.
So, again, out on latency period under either Dr. Hudson's drug-induced liver injury testimony in general or Dr. Freeman's hydrazine-specific latency testimony. Can we go to the COSNET? Let's go, John, please, first to his opinion in the report at page 10. Your Honor, Dr. COSNET is the plaintiff's medical toxicologist. He's the one who gives opinions about what dose of water would be required to cause a liver injury given the known values of hydrazine. All right. So in his report, which Mr. Stevens is going to pull up here,
This is an exhibit.
I think I gave you the report separately, John. It might be in Mr. Belsky's grouping. Yeah. Let's see page 10, please. One more, if you would, John. Thank you. I think we need to go one more page. Yeah, let's pull up the bottom paragraph, please. All right, Your Honor, now there are a few concepts here that the court will recall. One is the degradation of hydrazine. But what Dr. COSNET does here is he makes some... You know, John, I'm sorry. That's Dr. Najim. That's not the one I was thinking of. Let's do this. Go to the COSNET slide, if you would, and we'll come back to Dr. Najim. That's my fault. Dr. COSNET, Your Honor, again, is the toxicologist for the plaintiff. And recall the Eurofins test results that showed a maximum of 300 micrograms per bottle. All right, so what Dr. COSNET says at page 94, line 5 to 10 of his deposition is that you need 21 milligrams per liter. And you need to be drinking that daily. You need to be consuming it regularly to cause injury. That's pretty consistent with what the public health authorities found. Now, one milligram, Your Honors, is 1,000 micrograms. So 21 milligrams is 21,000 micrograms. Again, we're only at 300 milligrams. We're at 1/70th of Dr. COSNET's minimal value that somebody has to drink daily to perhaps get a liver injury. Now, if we...
Well, here's my next question.
Yes, sir.
Do we know the levels of hydrazine that were in the bottles that were being consumed at the time of consumption?
We know this, Your Honor. Dr. Najim, please, page 10. We know that the plaintiff's experts opine that it degrades over time.
Right.
The plaintiff's expert, last sentence there, John, if you would call that out. The plaintiff's experts can't calculate that number. But again, the plaintiff's experts put the outer limit of that at 10 times what we found when we tested.
But my point, I guess the answer to the question I had was we don't know.
We don't know. What we do know is that we're well short of it. We're well short of it.
And that would be well short of it after degradation.
After degradation, because if we give Dr. Najim every possible benefit of the doubt, He's saying here, I might say that it's 10 times as high. That's 3,000 micrograms. That's still 1/7 of what Dr. Kosnet says is required to drink every single day. And recall that neither Mr. Haley nor Mr. Belsky were drinking this water with anywhere near that frequency. All right, so Your Honor, we have latency times 2, Hudson and Freeman. We have toxicity times 2, even accounting for degradation, Kosnet and Najim. We're nowhere close to the numbers, and we're nowhere close to the injuries. We're many, many months away. Haley's testimony is sporadically, a handful of times, 5 to 6 bottles total, with one of those being documented 17 months prior to his illness. Belsky's testimony is 1 to 2 liters a week, not a day, that I stopped 7 months before my hospitalization in May of 2018. They don't come close in terms of latency, and they don't come close in terms of toxicity. And so, Your Honor, for all of those reasons, according to their own sworn testimony and their experts' own opinions, they fall well short. And that's why UNFW should be entitled to summary judgment on their individual claims. That doesn't, again, kick them out of court. That doesn't deny them their recovery. Mr. Haley's already accepted an offer of judgment. He still has claims against the metering defendants, as does Mr. Belsky, who also has a claim against the delivery.
How do you feel about
Your Honor, we filed a joiner. I'll be heard on that at some point.
I will be.
Your Honor, I'm happy to answer questions the court has, but according to their experts' own testimony, neither Mr. Haley nor Mr. Belsky are temporally or quantitatively plausible cases.
Thank you, sir.
Thank you, Your Honor.
Mr. Rasmussen.
I think Mr. Neale's done a fairly good job of explaining to the court a lot of the signs with regard to the hydrazine and its ability to be in the concentrate. First thing, and the facts area that I want to make sure is explained to the court, is that this particular consumption by these two specific individuals would have been from water, not from Henderson. It would have had to have come from the Desert Inn facility. And I believe
And that's
that,
because of the retail bottles.
yes, but it's also a timing thing. So,
And because the Henderson plant didn't open up into a certain time period, right?
yes, Your
I
Honor.
understand that.
Okay, I just want to make sure that we understand when that would have occurred. At the Desert Inn facility, there were 2 different production lines. One of them was the person who did for instance, the ORP meter, which is what I'm interested in, is a man by the name of Diego Mendegana. And I can be pronouncing that incorrectly. So I'll spell it for the record, Mendigana. Okay? He's working on the retail side. He states in his testimony that he never worked on the 5-gallon jug side. Okay? That's his testimony. So then the question then becomes, with all the time periods that we're dealing with here and the ORP meter, was there ever a time that Mr. Mendigana ever added more concentrate? His testimony, different than Casey Aiken's, is if it was low, I would add a little bit more. Okay? In other words, if the ORP meter reading was X, let's say negative 130, then I would add a little bit more concentrate. How often? Sometimes, he said. That's as close as we can get to this. That's all that we've got. Circumstantial and speculative evidence at best. Mainly speculative. What time period? When did this occur? How often did this occur? Was never asked by plaintiff's counsel as to timing on any of that. We have no idea.
But I mean, as far as that's concerned, Real Water has no idea.
No, they never did any, and yet what's
Well,
happening.
that's what I said, they never did any testing for hydrogen.
No, the point is,
I mean, that's part of the dilemma, right? And I understand this was an unforeseen, what did I call it,
unintended.
unintended. I get that, that's probably the fairest way to say it. But go ahead.
So we're being held to the standard of trying to figure out what these people are doing when we don't know for these two at a different facility. That fact is not uncontroverted. 2018, 2019, up through June of 2020, different facility, different person, okay? These two alone are in that particular facility's water, and that's it.
And I guess this is uncontroverted, right? There was no QC, quality assurance type program in place.
There is, yes,
Well, I mean,
by Real Water.
Yeah,
Whatever they want to call that, yes, they do have one, yes.
thank you.
all right, well, I mean, that was the receptionist that was running that,
There were different people at different times,
right?
okay? Yes, one of them was the receptionist. That then became the quality assurance. But there are other people that are used in that particular facility that are doing other things, okay? The superseding intervening cause of action, though, is when did you decide to do this? Well, if we saw this number, then we would do this. And if we saw that number, we would do that.
That doesn't matter. At the end of the day, it's the product and what condition it was in when it was manufactured, distributed, and so on. And that's why I always come back to it. I mean, the principles of strict products liability under the restatement of torts 402A is fairly straightforward. And I understand you made a comment a couple of days ago, Judge, what did we do wrong? Well, it didn't matter what you did. What you did wrong was you distributed the product.
I didn't.
I mean,
We sold an ORP meter that takes
ORP.
measurement. Right.
Well, and my point is this, I understand your claim is different, I do, I get that, you know, and I understand your position and frustration. But once again, and I said this earlier, it doesn't matter whether it's, as far as the claims are concerned, whether it's a issue regarding warnings and the like, product
Okay.
insert packaging, that can lead to a product's liability. Whether it's a defective design, that can lead to a
It's
product's liability.
not here on this.
Yeah, or it's a manufacturing defect. Now,
Not here either.
yeah, but my point is, you're at the first level. The other, everyone else is at the second level. It could be design and or manufacturing, it could be both. I mean, I'll listen to see what the experts say, but in this particular case, I can see a little bit overlap eventually. But my point is this, and it doesn't matter what you did or didn't do as far as your client's concerned, because at the end of the day, I would anticipate, and I haven't heard the arguments on this and stuff like that, but one of the key issues is going to deal with adequacy of warnings and those.
We look forward to that. argument.
Yeah, but you understand where I'm going.
I do, I
That's why
understand,
you're
and I
here.
get that. The question then really is that if the warnings are inadequate, it has to lead to the result of an inaccurate reading or measurement. And therefore cause the injury. We still have to have causation, right? And you still have to, this ORP measurement that only measures electricity, okay, has to cause the injury to these particular 7 people.
Well, here's my next question, we haven't gotten there yet. And I would anticipate, as far as product warnings, insert, boxing, and those types of things, the plaintiff has an expert specifically relating to the inadequacies of those things, correct?
Well, he doesn't have, and this will be part of another motion to eliminate, because he doesn't have any experience in anything scientific, he can't give me the exact language he would use to put into and would trump, or he would say, this is better language to use. He can't do that because he's not a scientist. He can just say, whatever you did do, that wasn't adequate because someone got hurt. That's what his testimony is going to be. Not that he has specific language that he's going to, because I asked him that question in his deposition. What language would you use then, Dr. Motley? And he said, I don't know. I'm not a scientist. I don't know these things. I can't tell you what the language would be. But I think it's inadequate because somebody got hurt. I don't know what does an ORP meter do? I don't know. I'm not a scientist. I can't tell you. Well, then what went wrong at the Desert Inn facility? I don't know. I wasn't there, which is true. But I wouldn't know what they were doing anyways, and I don't know what hydrazine is, and I don't know how the people got hurt, and that's all I can tell you. The problem is that I've got to have a link causally from the ORP meter to the consumers down here. And what has to happen is, well, you know what? They didn't condition it right because they didn't know how to read the instructions. Mr. Motley, what instruction didn't they know? Well, it wasn't calibration. We knocked that one out, although there was still, I'm going to give Mr. Kemp the benefit of the doubt on this. He uses the word calibration in his deposition, but I really think he means conditioning. Because it's a self-calibrated, in-factory calibrated machine, meter, okay? The ORP meter is calibrated at the factory. So calibration's not something you can do when you bring it to the Desert Inn facility, or the Henderson facility, or any facility for that matter. Cleaning's on the table, and Mr. Motley said that in his depositions. I'm not critical of any of the instructions having to do with cleaning, okay? So then we have this conditioning thing, and that's where I think that they're saying, but I've got to have a causal link. I can't just link to the consumers, right? I still have to. That even in strict product liability, I have to be the cause of their injury.
Yeah, well, it's that, yeah, I mean,
That's the law.
Yeah, but we'll, I don't know if this motion can directly impact.
I agree. I joined it. I don't think these two can be causally linked to that because this was different place. Mr. Kemp's argument till now, and I understand it, is Casey Aiken got this ORP meter. He said, what do I do, boss? Add more concentrate. And he doubled it up. And then we have 5 people all in the outbreak who get sick. Okay? And as Mr. Kemp told the court, yes, he meaning Casey Aiken, doubled the amount of the concentrate, thus doubling the amount of the hydrazine. I don't think that's correct, okay? For lots of scientific reasons. But we'll get into that later down the road. The point is that we're dealing with these two guys down here whose latency periods on all of this don't work, and the readings that were taken, there's no point in trying to go to the speculative area that say that we were causally the reason that hydrazine ended up in these people, in Mr. Belsky and Mr. Haley. There's no way to get there. Which is the whole argument that we had yesterday about what function did my client have to do with hydrazine. And Mr. Kemp again said, Mr. Rasmussen's right. This has to do with warnings on a box. Okay, and your expert can't tell me what warning was wrong. No, but people got hurt, so that's enough. Okay. That's off of this, and we'll deal with that down the road. But I've joined to this. I don't think these two should be anywhere near these sort of things. The periods of time don't work. I fully support everything that Mr. Neale said. I think he's right on. I think this court needs to seriously consider this motion for summary judgment, and that it just doesn't work. And with that, I'll sit. Thank you,
Yes, sir. But they have Mr. Odou, sir.
Your Honor, I do not believe that Real Water joined this motion, and if we did join it, we would withdraw it. We don't agree with this motion.
Okay, thank you, sir, interesting. Mr. Parker,
Your
what you
Honor,
have to ask?
this may take a little bit of time.
Everything takes a little bit.
I truly thought that this would be a short, oh, there it is.
Before you begin, maybe we take a quick break?
You want to, yeah,
Let's just lengthen it a little more.
I'm
That's fine, I'm fine.
No,
I'm fine, I'm just teasing.
Mr. Rasmussen, you're right, we're approaching 3 o'clock, we'll take a break at 3, and we'll give Mr. Parker a chance to set up.
So you're saying that was a good move on my part?
Yes.
Okay.
I said you're right.
All rise.
Thank you, ladies and gentlemen.
Department 16 on that. Return back to session. Please be seated.
All right, we're back on the record. Mr. Parker.
Yes, Your Honor. Before we get started addressing what I believe to be the merits of the motion, or perhaps what I believe not to be the merits of the motion, I want to harken back to plaintiff's opposition to UNFW's motion in limiting number 19 to exclude testimony from William R. Hudson, MD. And I bring this up because this seems to be where Mr. Neale left off. And so, Chris, if you could go to page 14. And the court denied the motion of limiting. And I just want to remind the court of the opinions of Dr. Hudson. Line 10, this is straight from Dr. Hudson's report, and he finds that in the case of Mr. Richard Belsky and Plaintiff Keith Haley, that both their acute liver failures were secondary to the consumption of real water. That's his opinion.
Well, that's actually on page 12 of the opposition too.
That's right, Tron. I brought it back because in the opposition to the motion in limiting number 19, we attached exhibit 24 and 25, and I thought it may refresh the court's recollection of how painstakingly we went through his opinion, his rebuttal report, and then his deposition testimony that I think we had on this screen for hours at a time, it seems. Your Honor, there is no dispute that our specific causation physician, Dr. Hudson, has indicated that real water retail bottles caused Mr. Haley's acute liver failure, and a combination of retail real water bottles and the 5-gallon jugs caused Mr. Belsky's acute liver failure. Something that I thought about after arguing motion limiting number 19, and then it was brought back to me when Mr. Neale was talking today. Your Honor, we were looking at a negligence claim, and I'm sure one of these cases has crossed your desk before when you were a practitioner. And you had a rear-end accident and 2 cars that hit the plaintiff's vehicle. 2 cars, 2 defendants. Would you would you require the plaintiff to determine which car caused the bulk of the damages? Or after the plaintiff has pointed out that both cars hit her vehicle, let's say it's a female plaintiff, and she was injured by both, in her opinion, and her doctor said, yes, she was injured by both accidents, would this court throw one of the defendants out because the plaintiff couldn't tell exactly which defendant caused the greater damage? Or would the court allow the 2 defendants, with their experts, to come and contest the severity of the injuries caused by those 2 defendants?
Well, typically, that's an apportionment argument that's made, and we have a Nevada case specifically on point regarding that. We do.
That's correct, Ron. And so when I heard Mr. Neale try to retreat to that type of argument, it surprised me because that's not how you win on a motion for summary judgment. It's simply not a winning argument. And then it made me go back to Rule 56, where this motion should start, and certainly where the court starts in determining the propriety of granting a motion for summary judgment. Rule 56 says, the court should grant summary judgment if the movement shows that there is no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law. There is no genuine dispute as to the facts. That's what the court has to conclude. When Mr. Neale tried to explain to this court why he believes, or why UNFW believes there are no genuine issue of material fact, he kept having to explain contradictory deposition testimony.
Question.
As soon as he started that, and as soon as the court pointed out to Mr. Neale inconsistent deposition testimony with the arguments being made, the court has no further discretion because the court does not weigh the evidence for purposes of a summary judgment motion. This is not a time for the court to test the credibility of the deposition testimony of all of the witnesses. So let's take Mr. Belsky as an example. If you could go to Mr. Belsky's deposition, Chris, page 88. And, Your Honor, this is in our opposition, starting at line 18. Here. Nope, go up a little bit so we can see the question. So this is what, in part, Mr. Neale was speaking of in terms of Mr. Belsky's deposition testimony. It says, prior to the 5-gallon deliveries, what was the quantity of real water you were consuming? His response is, it's really hard to recall. I would say definitely no less than 1 of those bottles per week, but it could be 2 or 3. It was my practice to shop regularly at Whole Foods, and during that time period also enjoyed the water. Keep going up a little bit more. I sometimes would stop in and just grab like a chicken salad or something like that and water and just pay in cash and leave. Let's stop there. Pay in cash and leave. Your Honor, one of the reasons why we brought the motion to strike was because we knew that UNFW failed to produce the cash transactions. And we learned during this process, after scrutinizing the declarations by Ms. Joan Anderson, by Mr. Craig Shank, and by Mr. Hempling, that unfortunately, the affidavits were inconsistent and there was an admission by virtue of not having cash transactions identified in those affidavits that we've never received them as a part of the 16.1 production. Now the court has defined the difference, I believe, and at the very least pointed out the differences between the obligations under 16.1 and the obligations under Rule 34. And I'll remind the court that under Rule 16.1, which is different than the Rule 34, it says a party must, which I always highlight this, without awaiting a discovery request, provide to the other parties. And it lists everything that a party must provide. Then it goes through the names of witnesses, the telephone numbers, and then A1A Romanet 2 says, a copy or description by category and location of all documents, electronically stored information, and tangible things that the disclosing party has in its possession, custody, or control. Your Honor, we've learned that in Reno, there were cash purchases or purchases of real water in 2018 of a certain quantity, 2019 a certain quantity, 2020. In terms of Belsky, we're concerned about 18. In terms of Haley, 2019. So Reno is Haley. Belsky is the two locations, would be the two locations in Las Vegas, the Fort Apache location in Charleston, and then a Lake Mead location, Your Honor. And we have no cash purchases for those two Las Vegas stores produced in this case to date. To date. And so when Mr. Neale gets up and parades around the court or presents to the court a binder thick of documents, when it comes to cash transactions in Las Vegas, those transactions are not recorded in those documents, period. Now, I believe he's admitted that those documents cannot be located. They cannot be produced. That's one of the factors in the Young Rivero case. When it comes to the Reno location, they didn't produce the cash transactions that did not identify an employee ID number. And I believe UNFW has finally conceded to that. So, what is the court required to do now? You know you have a party who's failed to comply with 16.1. We have a party that's trying to use documents in a motion for summary judgment to contradict the testimony of its own employees. UNFW's counsel is also Whole Foods counsel. Whole Foods counsel has had the benefit of the deposition of Whole Foods employee Mr. Haley, who's also a plaintiff, Sarah Sandstrom, who's also a Whole Foods employee, cashier, Lori Kingston, Whole Foods employee, cashier. All three of these employees, one being a plaintiff, have testified that within the latency period, they sold real water retail bottles to Mr. Haley. Undisputed. And with that alone, you can deny the motion for summary judgment. When it comes to Mr. Belsky, I want to continue on here. Mr. Belsky says he would pay in cash and leave. It's really hard for me to remember the individual times that I walked in and bought the water. Go further up, Chris. But no less than one of those bottles a week. It could have been 2 or 3. Your Honor, he continues to provide further insight into his consumption. Next question by Mr. Neale. And that was up until the home delivery, then that stopped. He says, if by that you mean purchasing, he says purchasing, then the answer is the real water retail bottles from Whole Foods then? He says, yes, correct. Keep going. And the only consumption of real water you would have had after that would be a stray bottle that may have still been in your cupboard. That is correct. So, Your Honor, we know that there were bottles in his cupboard because not only is he saying it here in his sworn testimony, but his mother, Maria Belsky, said it in her deposition testimony. So, I guess Mr. Neale is inviting us to commit error by having to weigh the sworn deposition testimony of Maria Belsky, Richard Belsky's fact sheet, Mr. Haley's fact sheet, Mr. Haley's deposition testimony, Lori Kingston's deposition testimony, and Sarah Sandstrom's deposition testimony. All of those stand against what Mr. Neale has spent an hour and 45 minutes talking about. Your Honor, when you consider all of the deposition testimony alone, the motion has to be defeated. When you consider the opinions of the experts who've opined that Mr. Haley and Mr. Belsky consumed adequate amounts of real water retail bottles in terms of Haley, and retail bottles and 5-gallon jug bottles suffered acute liver failure, be it Dr. Hudson or Dr. Freeman, again, you have to deny the motion. Mr. Neale has said nothing and has provided you no information that would support that there is no genuine issue of material fact as required by Rule 56. Nothing. In fact, he's proven just the opposite. What I also found to be troubling and perhaps a reoccurrence of a constant theme here, Mr. Neale argued in part that there were no similarities in the symptomology between Mr. Belsky, Mr. Haley, and the similar incidents that the court has already ruled upon in the prior motion. And this line of questioning dealt with, did you smell anything odd? Did you see anything weird in the bottles? Was the bottle,
Well, actually, when I made that determination as far as the factors I was considering, I was pretty clear in this regard. That went to quality assurance and or quality control.
that's right,
And that's part of the allegations I would anticipate that resulted in the defective product in this case, because they had no quality assurance, they had no quality control. I would assume it may be inadequate training. I can think of a myriad of different issues that could be raised. But I was pretty clear there because it went to quality control or lack thereof.
that's right.
That's why I ruled that way. And I looked at the Nevada cases and, yeah, I came up with my factors, but it appears to mirror some of the prior decisions of the Supreme Court, like, for example, in Nexus.
That's
That's
right.
why I did it that way. And the reason why I did it that way is so at the end of the day, the Supreme Court can at least look at my logic, and they can agree or disagree with it, but at least they know what I was saying.
Yes, sir. And Your Honor, you're spot on, because the rules dealing with motions eliminate somewhat different, but in terms of motions for summary judgment, the rule requires that the court provide a rationale on the record as to why it grants and denies. And I think you've done a tremendous job of spelling out the legal and factual reasons for your positions, for your decisions in this case, Your Honor. But the reason I harken back to this is because Mr. Neale, perhaps on purpose, did not want to address the similarity in symptomology. All of these similar incidents that where you saw complaints in terms of symptomology were very similar.
I understand this. This is kind of what I come back to as far as this case is concerned. And I realize we have Dr. Hudson has opined to a reasonable degree of medical, well, it says certainty, always necessary, it's probability. We know that, more likely true than not. But has he backed off his opinion?
No. Dr. Hudson has not backed off his opinion. Dr. Hudson has said that they're within the latency period. And it's backed up by the testimony which we went through of Sarah Sandstrom and Lori Kingston. In fact, Chris, let's bring up, I believe it's Miss Sarah Sandstrom, page 15 of her deposition. So the question here, line 10 of her deposition, Your Honor, and this is during questioning by Mr. Pepperman. So if he testified that he was drinking real water in the spring through summer months of 2019, would you have any reason to dispute that? She says no. Now, Mr. Neale doesn't like that testimony. He objects to form. But the point is, Mr. Haley was admitted to the hospital in August of 2019. This is the summer that they're speaking of, well within 20 weeks of consuming real water retail bottles. Go to page 38, please, Chris. Here we go. So go up a little further. Go up a little further to 37. I want to see who's going to get the first line of the question. Further up. All right, here we go. So lines 8 and 9, Your Honor, it says, how many times do you specifically recall ringing out Mr. Haley? And she goes through what I think is funny. She says, so I use the word couple to few because it had to have been 2, maybe 3, but again, I don't recall how many times. What if it was more? I don't remember because, again, we made the joke about the water. We're not going to make the same joke every single time. It's not going to be something that's permanently stored in core memories. So I can't give you a specific number because, again, I'm going to just say a couple. Don't know which one I should say, 2 or 3. Keep going. Then it says, that's okay, just, you can't give us a specific number. You can't give us a specific date on which those transactions occurred. No, God, no, sorry about that. Keep going. That's quite all right, and that's why I want to make sure nobody's trying to put words into your mouth. But you don't know what month those transactions occurred in, do you? No, again, I ring at the register every day, it's just, a blur. And here we get to the spring and summer again, Your Honor. I believe this is under question by Mr. Neale. I understand, and the answer is, I'm going to stick with what it had to have been, like spring and summer sporadically throughout that time frame. But again, I can't give you any months or dates. And she said earlier, oh, Mr. Neal is asking me to go further. I'll do that to save time, Mr. Neal. Go on. It says that even more specifically, you can't be certain of the calendar year in which the transaction occurred, can you? No, I think it was early 2019. Thank you. All right, Mr. Neal, you're getting, I'm giving you a lot of it. Early 2019, I believe so. Now, Your Honor, in previous testimony, she said she didn't believe it was 2020 because that's when COVID happened. And she also believed it wasn't 2020 because of Burning Man. So she believes it was spring or summer of 2019, and Mr. Haley went to the hospital in August of 2019. Well within 20 months, and again, well within the latency period.
You meant 20 weeks?
20 weeks, I'm sorry. Thank you, John. So you have testimony that we presented in our opposition, John, which goes to Mr. Haley's fact sheet. There's deposition testimony from Mr. Haley himself. And there's deposition testimony of Lori Kingston. Can you go to our opposition to this motion, this page 5? At the bottom here, thank you, Chris. Ms. Kingston is being questioned about the quantity of transactions of real water with Mr. Haley. So the question is, do you have any estimates? Was it more than 20 or 30 about the number of occasions in which you personally observed Keith Haley drinking your water? I feel he bought it very often, so between 10 and 20. The next question, during the time period between February, March, April, and August of 2019, did you ever personally sell real water to Keith Haley while working the checkout counters at the Reno Whole Foods? Yes. So you personally, going to page 6, so you personally sold real water to Keith on multiple occasions? Yes. Would you describe the number of occasions as several? Several. Your Honor, there's no way in the world this court should be asked to grant a motion for summary judgment when you have testimony, sworn testimony like this, of employees of Whole Foods indicating that the plaintiff purchased real water within the spring and summer, perhaps up to 10 to 20 times, leading up to his hospital admission. Right below that is the testimony of Ms. Sandstrom. And this is what I was telling you about earlier in terms of why she believes it was 2019. So the question is, we'll start with the question, okay, early 2019. And then it follows up, what enables you to say that it was spring of 2019 instead of fall of 2018, Ms. Sandstrom, if I could ask? Because fall, we usually have our Burning Man. Huge ordeal with Burning Man. We're very busy. I usually go on vacation. Just from trying to pull up my memory of the situation, I just remember it being earlier in the year. But I feel like it was 19 because then the following year we had COVID and it was hectic. So we have a relationship between COVID, Burning Man, and what she believes to be the time period that these transactions took place. And that's Ms. Sandstrom. And if you go to page 7 of our opposition, again, she says she remembers him buying real water. So, Your Honor, the testimony is there. We put it in our opposition. There is no dispute that these witnesses testified as represented in our opposition and consistent with what we put before the court on the screen over here, Your Honor. On page 8 of our opposition, we talk about Mr. Belsky's hospitalization in May of 2018. And then towards the bottom of that page, we discuss what I've already shown the court, Ms. Maria Belsky's testimony. I would also refresh the court's recollection, because this came up before on page 9 of our opposition, that Ms. Belsky remembers those real water bottles being sealed in the refrigerator when she was there while Keith was in the hospital. I mean, that type of evidence can't be ignored. And there's no explanation.
Well, there's two types of evidence, circumstantial and direct, and both of them are given equal weight.
That's correct.
Pursuant to the jury instructions.
That is correct, Your Honor. And here, Ms. Belsky is saying there were sealed bottles of real water, retail bottles, in the refrigerator. Mr. Belsky referred to in his deposition as in the cupboard, and it's there. Mr. Neale started off with a reference to the Wilson versus Circus case. That's the 1985 Nevada Supreme Court case. Again, Your Honor, you pointed out to Mr. Neale and Mr. Rasmussen, that's a negligence case. It's not a strict product liability case. For some reason, it finds its way into their arguments way too often. The other thing I found curious about Mr. Neale's argument was how he believes that the Southern Nevada Health District's definition supports his position when it's convenient. Because it was Haley and Belsky, in his opinion, they do not fit within the definition because it's 2018-19 versus 2020, and it's 5-gallon jugs versus retail bottles. But when you look at everything else, the symptomology,
But they're not the ultimate arbiter.
they're not.
I mean,
Like I said, he believes it's a safe harbor for some reason. I don't understand why.
I mean, if that's the case, this case wouldn't be in trial. Whatever the health district finds, that's what the liability is, and I would make my job easier. Then I determine whether there's damages or not.
That's right. And it's because they did not look at 2018. They did not look at 2019. The MMWR report shows spikes during 18 and 19. The Southern Nevada Health District is not the arbiter of what cases of acute liver failure were caused by the consumption of real water. Mr. Neale, for some reason, and I thought this was funny, Mr. Neale says it's like with the plaintiffs, it's like playing whack-a-mole. We ask for something and he gets it, and then we ask for something else, he gets it, and it's difficult, I guess, getting a handle on our requests. Well, when you force a plaintiff to make a request because you fail to simply produce what's required under the rule, perhaps it feels like whack-a-mole. But what it feels like to the plaintiffs, when you have a defendant not complying with the rules, it feels more like in New York City, where you have somebody playing 3-card model, and you get the shell game. You shouldn't have to do that in discovery. Rule 16.1, there's a reason behind you having to produce everything without the need for a request, because it allows the parties to start the discovery process with the universe of documents potentially. You asked this question of Mr. Neale, and he indicated that he could give you the dates for all the supplements to the 16.1. I'll remind the court. The initial 16.1 by UNFW was October 15, 2021. We did not receive and have not received all cash transactions without the use of an identifier, like an employee identifier, to this date. If you go to 16.1, 1A, Romanet 2, it says what the obligation is when it comes to documents. The supplements that he's speaking of that said Whole Foods on it came in January and March, and then in June of 2023, almost 2 years later. We should have had every cash transaction for the real water retail purchases at the 3 Whole Foods locations in the beginning of this case, because they knew there was no reason UNFW did not know that they were going to use the quantity of consumption as a defense in this case. Because certainly we know they've been using it throughout all of these motions. And they knew it then. Trying to hide behind a request for production of documents flies in the face of the requirements of 16.1. Your Honor, in our NRCP 56A and B requires that there be no genuine issue of material fact. And when it comes to B, all we have to do is produce depositions, written discovery, declarations to defeat a Rule 56 motion. We provided 5 depositions of lay witnesses, 2 expert depositions. We provided declarations in the form of fact sheets from both Mr. Haley and Mr. Belsky. There's nothing else the rule requires of the non-moving party to defeat a motion for summary judgment. For those reasons, Your Honor, we ask that the motion be denied.
Okay, thank you, sir.
Thank you.
Your Honor, I apologize. Mr. Parker and I had originally split this up. I have a few other things to add on this if it's acceptable. I don't intend to tread the
Any
same ground.
objections?